The first time I heard it, I was still in law school. My summer internship was with this grizzled, chain-smoking civil litigator named Murray, who kept one tie on his office coat hook and a bottle of bourbon in the bottom drawer. "There are 3 duties you owe as a lawyer," he said. "First to yourself, second to the court, third and dead last, the client." I blinked. That wasn't what they taught us at school. He leaned back, dragged on a cigarette, and said the words that burned into my brain. "Because clients will fuck you. And when they do, it'll be with a smile." I didn't believe him. Not then. Not until years later when I had to learn that lesson the hard way. Flash forward a decade and change. I'm mid-30s, hardened, polished, and one of only 3 women partners in a boutique litigation firm in the financial core. My work: contracts, corporate, real estate, insurance, the kind of things people yawn through on paper, until millions are on the line. That's where Frank came in. Frank was the operations director for one of our clients, a mid-sized property and asset management group with holdings scattered across the city. Technically, he wasn't a C-suite exec, but in practice, he ran the show day to day. And Frank? Frank was the type of man who kept every receipt, argued over $37 invoices, and treated lawyers like vending machines. Punch the button, get the result. He never respected what I did. But he needed me. Even if he didn't know it yet. The trigger was a building fire. One of their older properties burned down. Electrical issue, faulty subpanel. The damage was extensive, total loss. But it was insured. Normally, this would be simple. You submit your proof of loss, engage counsel, and the insurer pays out. But Frank, God bless his arrogance, thought he had it handled. "I've got a good relationship with the adjuster," he told me. "Frank," I said, "they're stringing you along. You need to file now. They're just being thorough. They're stalling. They'll pay. I trust them." I didn't roll my eyes. Not in front of him. But I did something else. Behind the scenes, I started quietly building the file. Got him to send me the proof of loss, just for review. Had my assistant pull the insurer's litigation history. Drafted a skeleton statement of claim just in case. I didn't file it. Not yet. Because there's a rule we live by in my world. You don't sue without instructions. Unless you're ready to risk your license. As weeks passed, I sent him warning after warning. Each one more direct than the last. "Frank, the limitation period is closing. If you don't act, you'll lose your chance to sue. Frank, I won't be reachable. I'm in trial. Pick a firm if it's not us. Just get it done." He ignored every one of them. Didn't reply. Didn't escalate. Didn't act. So I did. I sued the insurer myself. Without instructions. Without approval. And with my neck fully on the line. Because I knew what was coming. And I wasn't going to let him drag me down with him. I didn't do it for Frank. I did it for me. For my license. For my reputation. Because Murray was right. Clients will fuck you. But not if you see it coming. Not if you're already 10 moves ahead. A month passed. Then another. I'd nearly forgotten the whole mess, buried under court motions, arbitration prep, and my usual mountain of high-stakes fire drills. That's when my phone rang. Blocked number. But I knew the voice immediately. "Hey, remember that fire insurance thing we talked about?" It was Frank. His tone? Nervous. Calculated. Almost hopeful. "Of course," I said. "So they paid the claim?" Pause. Too long of a pause. "What claim?" he asked. I blinked. Laughed once quietly. "The lawsuit. The claim we filed. The one you said you didn't need because you had it under control." Another pause. Then click. He hung up on me. I stood in my office, phone still in hand. So it finally happened. 5 minutes later, my email pinged. From Frank. Subject: urgent insurance claim. And in that message? Gaslighting. Careful corporate crafted lies. "As per our previous discussions, I instructed you to initiate a claim. I've been patiently waiting for confirmation of service and would appreciate receiving a copy of the filed materials at your earliest convenience. Read like a legal briefing to cover his own ass. Fake concern. Fake memory. Fake timeline. I didn't reply right away. Instead, I opened the folder. My Frank folder. And it was full. Every warning. Every reminder. Every, Frank, I need you to act. Every limitation period is approaching. Every, I won't be reachable, so this is your last call. They were all there. Time-stamped. CC'd to my assistant. Properly labeled and sorted because I'm not a rookie. But now I needed to do one thing I'd been putting off. I looped in Bill. Bill was in-house counsel for the client, the guy who actually understood risk, exposure, and consequences. A lawyer. Like me. Fluent in the language of receipts. I forwarded Frank's email with a single line of my own. Take it this means the insurer denied the claim, exactly as predicted. Just for the record, please see attached. Attached were all 14 warning emails I'd sent over the past few months. Every one of them ending with, "You must sue." Bill responded within 2 hours. He didn't ask dumb questions. He didn't defend Frank. He just wrote, "Yikes. We'll call you this afternoon." When he did, his voice was tight. He said he told you to sue, but it's clear now he didn't. He told me to leave it alone, that he had it under control. He's saying the opposite, that you missed it, that you dropped the ball. I smiled. Then why did I sue anyway? Silence. Then, wait, you filed. Yes, on my own, no instructions, because I saw this coming. He didn't say anything for a moment. Just breathed. And then, a long exhale like the pressure in his chest had finally broken. You saved our asses. You're welcome. We need to talk next steps. Can I leave this with you? Absolutely. And just like that, Frank was no longer my problem. He tried to throw me under the bus. But instead, I handed his lies back with a bow. 2 days after my call with Bill, I got another message. Not from Frank. Not from Bill. From someone I barely dealt with before, an operations junior named Evan. Subject, quick file update, time sensitive. I opened it, curious. The body of the email was short. Hi, just letting you know I'll be point on the claim going forward. If you need anything from the client side, I'm your contact. Appreciate your help on this. That was it. No, Frank is unavailable. No, he's on leave. No, he's taking a step back. Which meant one thing. Frank was done. I texted Bill. So, Evan. He replied 5 minutes later. He's out. We handed him a box. Security walked him down. It wasn't subtle. I stared at my screen. No smile. No fist pump. Just quiet satisfaction. This wasn't revenge. It was math. Cause and effect. Bill called me later that evening. The board saw the emails, he said. Yours, his, all of it. And the difference was night and day. He looked like an amateur trying to bluff his way out of negligence. He was. They didn't even need debate. 1-page letter. Done. I nodded. So where does that leave the file? With you. Evan was green but competent. And refreshingly not arrogant. He actually said, "Thank you," when I walked him through the procedural posture of the filed claim. He didn't argue about costs. He didn't question the hourly rate. He didn't try to second-guess my litigation strategy. It was almost unnerving, how painless it became. When Frank was gone, the silence was golden. But Frank wasn't done. Not yet. Because toxic men don't just fade. They circle back. They lash out. They try one last play. And Frank? He went to the one place he thought he could still be heard. He tried to file a complaint. It came through as a notice to my managing partner. An anonymous tip, claiming I'd filed a legal action without client authority, that I'd put the firm at risk, that I'd lied to cover my own incompetence. The words were familiar. I knew who'd written them, because only one man tried to rewrite the story when he'd already lost the plot. I walked straight to our compliance officer, printed emails in hand. I didn't just defend myself. I documented every decision. I included a timeline. I included my notes. I even included the PDF of the statement of claim with the filing timestamp. The firm? They laughed. Hart. This is airtight, the managing partner said. He tried to torch you and didn't realize you were fireproof. He tried, I said. He failed. That was the last I heard from Frank. He disappeared, probably into semi-retirement or maybe consulting. Guys like that always find some corner to fester in. But around our firm, he became shorthand. Don't pull a Frank. Is this client a Frank or a Bill? Remember what happened to Frank. He wasn't just a cautionary tale. He was a warning label. Me. I wasn't angry. I wasn't even proud. I was just ready. For the next one. For the next fool who thought my silence was weakness. Because I don't shout. I file. With Frank gone, the claim became mine. Officially. Finally. And entirely. And unlike Frank, I didn't waste time. The moment Evan forwarded me full access to the internal loss files, invoices, and damage assessments, I went to work. Not just filing paperwork. Tightening the noose. Let me explain how insurance litigation works when the stakes are high. Insurers don't fear damage. They fear exposure. They fear pattern, precedent, headlines. And when I filed the claim without instructions, weeks before the limitation expired, I'd made them vulnerable. Now that we had updated documentation and the client's formal blessing, I had them cornered. I amended the statement of claim within days. Clean, bulletproof language. Detailed attachments. Sworn affidavits from property managers and fire investigators. A professionally reconstructed timeline of the fire, inspections, and communication trail, including delays and stonewalling by the insurer. And in the cover letter to their counsel? Just one sentence. Attached is the amended claim, along with our full intention to proceed unless resolved within 14 days. Translation: settle now or bleed slowly. It took them 11 business days and 3 phone calls before I got the email. Subject line: without prejudice, settlement proposal. They didn't even haggle. The amount: full policy value. No argument about depreciation. No quibbling over fire cause. No attempt to deny liability due to paperwork. Just payment. Fast. Why? Because they knew if this went to trial, they'd not only lose, they'd lose loudly. I forwarded the offer to Bill and Evan with a single line. As expected. Evan responded in under 5 minutes. Unreal. Frank told us this would drag for years. I smiled at the screen. That's because Frank never sued them. Bill and I got on a call that same afternoon. You want to push for more? He asked. We could, but we'd spend $100,000 in litigation for maybe $50,000 more. So we take it? We take it. I handled the paperwork. I arranged the payout logistics. And I closed the file. From a legal standpoint, it was over. But for me, it was just beginning. Because now, with the client whole and my instincts vindicated, I had the freedom to do something I rarely allowed myself. Tell the story. At least in the right circles. Bar associations. Mentorship drinks. Late-night text threads with other women in litigation. You remember that thing I told you about clients who try to bury you? Wait till I tell you about Frank. Not to humiliate. Not to gossip. But to teach. Because too many junior lawyers, especially women, try to be liked more than they try to be safe. Too many bend until they break, because they're afraid of confrontation. I'm not afraid anymore. Because I saw the worst of what a client can be. And I walked away clean. In a business where most cases settle quietly, this one stayed with me. Not for the payout. Not for the firm. Not even for the revenge. But because of what it taught me. Trust your gut. Save your receipts. And sue even if they tell you not to. The check came fast. It cleared even faster. Evan emailed me a brief thank you with the wire receipt attached, and a short note about how impressed the CFO had been with my efficiency. It should have ended there. But it didn't. As I saw the NDA. It came a few days later, slipped quietly into a forwarded email from the Insurers Council. Subject line, Settlement Finalization, NDA Draft Attached. The body was polite. Too polite. Which in legal speak is a red flag. In exchange for the settlement funds, please see attached a draft non-disclosure agreement to be signed and returned. I opened the file. And my jaw twitched. Let me break it down. NDAs are common. Expected even. They protect reputations, prevent PR damage, and keep dirty laundry off the public docket. But this was aggressive. They wanted a blanket gag order on the fire itself, the handling of the claim, the delay, the involvement of Frank, my name as legal counsel. In short, they wanted the whole thing erased. As if it never happened. Evan called me the next morning. We're good to sign, right? No. What do you mean? I mean this NDA isn't standard. It's scorched earth. He hesitated. We already got paid. What's the risk? The risk, I said, is precedent. If we sign this, they get to pretend they didn't stall for months and almost cost your company millions, because one incompetent manager ignored a dozen legal warnings. But it's over. Is it? Silence. Then, what do you suggest? We modify it, narrow the scope, remove personal language, leave in only what matters. I spent that weekend drafting my own version. Tighter, smarter, and far more dangerous for them. Because I left just enough open for the record to breathe. A record where the insurer acknowledged they had delayed unfairly, and that a lawsuit was necessary to clarify matters. Was it a public admission of guilt? No. But was it a paper trail that showed they settled fast after litigation began? Absolutely. And that was leverage. Their counsel pushed back. Of course they did. Tried to soften clauses. Tried to smudge lines. Tried to hide behind standard language. I didn't budge. In the final version signed and sealed we kept the admission that the claim was triggered only after suit was filed. The acknowledgement that timelines had lapsed during negotiations. A clause stating the client had received multiple warnings from legal counsel, which were ultimately acted upon in the interest of timely resolution. They left my name in. By force. Why did that matter? Because years from now, when another lawyer at that company reviews old case files, when they look at why the insurance settled, when they ask who saved this file, they'll see it. My name, my work, my timing. Because I don't fight for the win. I fight for the record. Frank wanted silence. The insurer wanted shadows. I gave them sunlight. Not by shouting. Not by gloating. But by drafting a document so precise, so quiet, so final, that no one could ever change the truth again. Not even with a pen. It started as a whisper. A hallway nod. An appreciative email from someone I didn't know well. Then a week later, coffee in the shared kitchen and a quiet, "Hey, you're the one who saved that insurance case, right?" I didn't answer at first. Just smiled. "It's been making the rounds," they said. "Nicely done." I had no idea what rounds meant. But I would find out. 2 days later, I had lunch with a senior partner. A woman I'd always admired but rarely interacted with. She slid into the booth with her usual grace and got right to the point. "Frank's old client called me," she said. "Wanted help on something new." "Oh." They specifically asked if you could take it. Said you saved their entire portfolio with one quiet lawsuit and zero noise. I blinked. Wasn't zero noise on my end. She smirked. That's the best kind of noise. Controlled demolition. From there it spiraled. I got a call from an associate at a rival firm. She asked, politely, nervously, if I'd ever give a talk on how to preempt client sabotage without setting the building on fire. How did you file without instructions and survive it? She asked. Receipts, I told her. Always. Receipts. But you didn't ask permission. No. I asked the situation. She was quiet. Then laughed. That's a line. You mind if I quote you? Only if you spell my name right. The most unexpected moment? Bar drinks, Friday evening. A few women I mentored, a few I barely knew. One of them leaned in. Did you really make Frank's phone ring on purpose to trap him? I raised an eyebrow. I didn't say that. But did you? I smiled. Took a sip. Let's just say he shouldn't have ignored 14 emails. And definitely shouldn't have CC'd himself into a corner. By week 3, the story had taken on a life of its own. Some people added dramatic flair. Claimed I waited in court robes with a smug grin while Frank was escorted out. Others said I had the insurer begging to settle. That I blackballed Frank from the industry. That I had his career on a string and cut it like a marionette. Not all of it was true. But none of it was false. Not really. It reached HR. Then recruiting. Then the managing committee. Not in scandal but in awe. Not because I'd taken someone down. But because I'd done it legally, surgically, and without making it personal. By month's end, they asked me to speak at an internal leadership summit. Your topic, they said, is how to stay professional while burning down bad faith. And I laughed. Biz now. Now I was more than a lawyer. I was a lesson. I didn't want revenge. But I got legacy. It was supposed to be an ordinary Thursday. Quiet inbox. A long drafting session planned. Maybe a 3 p.m. coffee break if I got ahead of the red lines. And then I got the text. From a paralegal I mentored once. Now working at another firm. Just 4 words. Is this your Frank? Attached was a screenshot. An email signature. Franklin R. Pierce, Senior Risk Advisor. New firm. New title. New narrative. But the same man. I looked closer. It was him. Different photo. New resume. But same writing style, same recycled buzzwords. Even the same habit of capitalizing strategy like it was a holy concept. And he was pitching, get this, risk oversight consulting for commercial litigation. Risk oversight. From Frank. I called my paralegal friend. Where'd this come from? He applied to advise our client relations team. Wanted to be our internal consultant for litigation triage. I didn't laugh. But I did exhale, slow and full. And we were close to onboarding him. His references looked fine. No mention of the situation. Of course there wasn't. Because men like Frank don't list their failures. They just edit their timelines. He sent me the resume. It was a masterpiece of omission. No mention of the fire. No mention of the lawsuit. And definitely no mention of the NDA with a clause that read, client acknowledges initial internal handling may have delayed resolution. I kept that clause. Because I knew someday he might try to rewrite the past. Now it was time to remind him, the paper still speaks. I didn't send a takedown. Didn't threaten legal action. Didn't call his new firm. I just sent one thing. A copy of the signed NDA, highlighted, annotated, and with the clause he helped write. And attached to it, a formal note to my mentee's GC. I believe this candidate was involved in this matter. If you need corroboration, happy to assist. That was it. No drama. Just evidence. She called me an hour later. "He's done," she said. "What did he say?" "Denied at first. Then stuttered. Then asked why any of it mattered now." I didn't respond. I didn't need to. Because what mattered now wasn't him. It was that a room full of people, including women who once thought they had no voice, saw how it ends when someone fights clean and wins. Frank didn't just lose a job that day. He lost the rewrite. He lost the lie. He lost his reboot. And me. I got back to my drafting. Coffee cold. Heart warm. Smile real. It was a Tuesday. Late afternoon. Elevator from the 12th floor to the ground. Just me, a coffee in hand, and a man in a tailored charcoal suit I half recognized. We stood in silence until floor 9. Then he turned, smiled politely. "You don't remember me, do you?" I studied his face. Faintly familiar. Sharp but softer now. "Give me a hint." "Bill," he said. "From the fire claim. The one you filed on your own." And just like that, it clicked. Same eyes. Same dry wit. But gone was the tension, the weariness, the background noise of someone constantly cleaning up someone else's mess. He looked lighter. "Wow," I said. "You look 10 years younger." He laughed. "I feel it." We stepped out into the lobby together. "I heard about Frank," he said. "Eventually everyone does. Do you know what stuck with me most?" I shook my head. He paused. "It wasn't that you sued without permission. It was that you knew we needed to be sued, before we did." I didn't speak. Didn't need to. He wasn't finished. "You saved that claim. But you also saved our credibility. If that had gone public, if the board had seen how close we came to losing it." He trailed off. "Then, you didn't just protect the company. You protected me." That made me pause. I'd never thought of it that way. But of course he was right. Because if I hadn't stepped in, it would have been his name on the blame list after Frank. We reached the doors. Bill turned back one last time. "If you ever want to come in-house, we've got a corner office with your name on it." I smiled. "I'll think about it." But we both knew I wouldn't. Because I wasn't made to sit inside. I was made to stand in front. Of judges. Of insurers. Of risk. He waved once, disappearing into a cab. And I stood still, in that lobby, heart beating with a strange warmth I hadn't expected. Not pride. Not ego. Just clarity. That even years later, even when the case is closed and the inbox is quiet, doing the right thing echoes. In some elevators, they take you exactly where you're meant to go. Boardroom. Glass walls. Too much chrome and bottled water. I was across from opposing counsel, mid-tier firm, trying very hard to act high-tier. The client was there too, but quiet. And next to their lead partner, a junior. Fresh. Maybe 2 years out of law school. Dark ponytail, nervous fingers, legal pad full of handwritten notes. She didn't say much. Just observed. Absorbed. Until one sentence from the other side of the table changed the temperature. Their partner leaned forward, smiling like a magician mid-trick. "Look, we can all agree our side acted in good faith." I cut in, calmly. "No, we can't." Silence. "You're welcome to argue that in writing. But don't confuse silence for consent." He blinked. Regrouped. Smiled again, thinner. And that's when she spoke. The junior. Soft voice. But clear. "Actually," she said, looking at her own partner, "the memo from February suggests otherwise. It shows we delayed formal response by 11 days. He froze. Her voice didn't shake. That could complicate the good faith argument depending on how the other side positions it. She didn't look at me. She didn't need to. Because in that moment, she won me. After the meeting, as they packed their things, she lingered just a bit behind. I caught her eye. "Good call," I said. She flushed. "Thank you. I didn't mean to, I just thought it mattered." It did. I handed her my card. When you're ready to switch sides, call me. She laughed, but took the card. And that was that. Back at my office, I sat down, and before opening the next file, I looked out the window and just let myself breathe. Because after all the fights, after Frank, after courtrooms and clients and compromises, that girl, she still thought it mattered. And she was right. We aren't just litigators. We're caretakers of truth. And truth doesn't retire. It was a networking event. The kind with too much champagne, not enough air, and a lot of forced smiles. I'd come for 10 minutes. I stayed for 2 hours. Because in the far corner of the room, I spotted a face I knew, but couldn't quite place. He was tall, older now, confident in that quiet, settled way. He spotted me too. Came over with the kind of nod that says, "We have history even if you don't remember it yet." "You don't remember me," he said friendly. "But I remember you. Try me. You're the lawyer who saved the Burnside portfolio." My chest stilled for a second. Burnside. That was the name of the property Frank had let burn, figuratively and literally. "I was junior counsel," he continued, "working for the insurer." That stopped me. "You were on their side?" "Not directly, but I was in the room. When your suit landed, when Frank tried to spin it, when the board scrambled to figure out how a junior manager almost cost them a litigation disaster. I watched him closely. And you shook the table, quietly, with precision. We settled not because we were scared of court, but because we knew deep down that if you'd sued early without instructions, you were holding something we hadn't seen yet." I smiled. "I was holding the truth." "Exactly." He sipped his drink, then leaned in. "But that's not why I remember you." "No. I remember because 3 years later, when Frank tried to sue us for wrongful termination, reputational damage, the works, I raised my eyebrows. That was new. He really did it. Tried to. Filed a claim in a small jurisdiction. Thought he could fly it under radar. Let me guess. He didn't list the NDA." "Nope. But your name came up in discovery." My throat tightened. "They used my name?" He nodded. "As proof of internal warnings. Your emails. Your timeline. The original draft of the statement of claim." I was stunned. He continued. "The judge dismissed his claim. Said, and I quote, 'The plaintiff had been given every opportunity to prevent this outcome and chose not to act. Responsibility lies with inaction, not with counsel who did her job.'" He grinned. "That line is now cited in at least 2 rulings I've worked on." I didn't know what to say. For once, I was speechless. Because this wasn't revenge. This was vindication. The kind you don't chase. The kind that finds you in a quiet corner of a loud room, years later. As he walked away, I stood there holding my glass, watching him disappear into the crowd. And for the first time in a long time, I realized Frank wasn't my story. I was his ending.